What I'm going to basically be talking about is sort of a brief introduction into what transitional justice is, and then a little bit about how I think about the debates that it generates, and finally look at a role, a very important role that the EU has played in pursuing transitional justice in the context of Northern Ireland. So background for anyone who has never come across the term transitional justice before, or has but isn't sure exactly what it refers to, the sort of context in which conversations about transitional justice arose were in many places around the globe that have in recent decades tried to transition away from extended periods of conflict and or repression to democracy is one common aim, or more broadly to a more peaceful mode of interaction and more just, even if not fully democratic. So you can look at South America, in Argentina, one of many countries that were following transitions upon periods of military rule. South Africa influenced a lot of conversation about transitional justice when it transitioned from apartheid to multiracial democracy. Similarly with Rwanda. Then Northern Ireland in 1998, when the Belfast/Good Friday Agreement was signed, ending the decades of the period known as the Troubles. There was the Arab Spring, where you had the toppling of repressive regimes like Hosni Mubarak, and Colombia, as it's implementing the peace agreement that ended 50+ years of conflict between the government and the FARC rebels. So one of the things that's characteristic of contexts in which repression or conflict occurs over an extended period is the commission of human rights violations, which are often committed on a very large scale, though the scale varies from place to place. It could be hundreds, thousands, tens of thousands, hundreds of thousands, in some contexts arising to millions. So just to give you an example, Colombia, as I mentioned before, which has a population of approximately 48 million, had more than 8 million individuals registered as victims since 1985, since the recent iteration of a period of conflict. And that include millions forcibly displaced, both internally within Colombia, and also you have large numbers of Colombians who left the country during the conflict, hundreds of thousands killed, tens of thousands and forcibly disappeared, tens of thousands subjected to rape and other forms of sexual violence or torture. And so the question of how you deal with this legacy of human rights violations in the context of trying to pursue a move and a shift to a better mode of interaction has been the question that dozens of societies have confronted. And they've chosen a range of tools to use as the mechanisms for responding to human rights violations. So you do see what many think of as the most morally required, or the response that immediately comes to mind when you think of serious wrongdoing, and that is criminal trials. So you have criminal trials at the domestic level, at the international level. You can think of the Nuremberg trials, or the ad hoc tribunal that was established for Yugoslavia, the former Yugoslavia, the ICTY. Another analogous tribunal was established for Rwanda. There's some examples of hybrid tribunals where you have judges from multiple jurisdictions, both the local jurisdiction and judges from outside that jurisdiction, jointly running criminal proceedings. But really, trials are, in many ways, the least prominent process for dealing with human rights violations. What you find alongside trials are things like truth commissions, which are official established ad hoc bodies with a particular charge for investigating a specified type of human rights violation that was committed over whatever temporal period of time the commission mandate lays out. So in the context of South Africa, there was a Truth Commission that focused on killing, abduction, torture, and severe ill treatment that was committed either by South African government security forces or by armed anti-apartheid groups. There's been talk about, as part of the dealing with the legacies of Northern Ireland, a Truth Commission of some kind to be established there. But what these commissions are trying to do is not only document who was responsible for perpetrating violations and enabling violations, but who also were the victims, what were the consequences of being subjected to a particular kind of human rights violation, and what were the underlying conditions that enabled wrongdoing. So that's another mechanism. Then you have amnesty, which is actually the most prominent response that's used, and that is where there's a removal of the prospect of liability, either criminally or civilly. So criminally, you're removing the prospect of criminal trial and potentially incarceration. Civilly, you're removing the potential for being sued by victims' families for whatever violation of human rights is specified, and that can be done in a sort of blanket manner. It can be done in an individualized manner. So in South Africa, the Truth Commission had an amnesty provision, and to be eligible, what you had to do was come forward and say, here are the rights violations for which I am responsible, and fully disclose what acts you committed, against whom, where the bodies are in cases where it's not clear where the victims' remains are. And in the case of South Africa, you had to show that what you did was not done for personal reasons, but was done for political reasons, either in the course of defending the apartheid regime or trying to contest the apartheid regime. The special jurisdiction for peace that's operating in Colombia right now has amnesty provisions as well for wrongs that don't rise to the level of international crimes. So they're not war crimes or crimes against humanity. And in that case, what you have to do is fully disclose what you did and show that it was not done as part of the drug trade or the war against drugs. So there's kind of the political nature is relevant as well, and trying to distinguish personal enrichment as a motive from more politically oriented motives. And it's only that latter that you're eligible for amnesty. There's also a lot of reparations programs that are established that either provide monetary compensation to individual victims or try to provide infrastructure that is supportive of victims, so more general programs, or symbolic reparations that can take on forms of memorialization, for example. You have public apologies, memorials, and then lustration. So this was very common in East Europe and Central Europe following the collapse of communist regimes, where given the need to bolster the legitimacy of new democratic institutions, and given the prominent role of security forces in the communist era, secret police in particular, and worries about whether officials in the new regime harbored sympathies for returning to a more communist-oriented regime. Lustration was a program whereby individuals who were trying to seek public office had to come forward and disclose any ties that they had to the secret police or roles that they played as an informer or collaborator. And then what followed varied depending on the country that you were talking about, either ineligibility for serving in certain roles or the public disclosure of these facts, and then voters could decide whether or not you would assume public office. But so that gives you kind of a sense of the different tools that have been used to try to deal with wrongdoing as part of this broader effort to transition to a more peaceful and in many cases aspirationally towards a more democratic mode of governance. So what I try to look at in my work is how should we evaluate these sorts of choices that are made for how to deal with wrongdoing, the choices of amnesty or truth commissions or criminal trials or reparations. And the field of transitional justice is very multidisciplinary. There's a lot of lawyers who are looking at questions of whether domestic responses are consistent with state duties according to international law. So whether state obligations to deal with wrongdoing, international crimes that were committed on their territory are being satisfied by the choices that are being made. You have a lot of social scientists who are trying to explain what are the factors that shape why amnesty as opposed to criminal trials or lustration as opposed to reparations, why those choices are made, or what the impact of processes is. Does trust among deeply divided communities increase? Is the rule of law enhanced? Are victims satisfied? So that's a lot of the questions that are asked. My question is slightly different. My question is a question of justice. So how should societies deal with legacies of abuses as they're trying to move to a better place? And insofar as we're going to say justice has been done vis-a-vis how human rights violations have been dealt with in these periods, what are the criteria that need to be satisfied? So the metrics of success. So I just wanted to say before turning to my positive account, so kind of why ask my question? Why ask the question of what are the criteria or the standards that you need to satisfy to show that justice has been done? So one reason is that people care deeply about whether or not justice has been done, especially when you're dealing with serious and often widespread egregious violations of human rights. And also, you can link up questions of efficacy with the question of how processes are perceived. So if processes are viewed as show trials or as blood money for victims or as, kind of this bureaucratic process where you produce a report and it's shelved and doesn't make a difference to a community moving forward, that can impact what kind of contribution processes of dealing with wrongdoing make to the ending of conflict or the establishment of more peaceful relations. And more generally, there is just deep fundamental disagreement, typically among citizens, about what justice demands when it comes to dealing with human rights violations. So I have some examples on this slide from Colombia. So when the Comprehensive Peace Agreement was negotiated over many years between the Colombian government and the FARC, the Revolutionary Armed Forces of Colombia is what FARC stands for. The final agreement was put to a plebiscite, and the plebiscite narrowly failed. And when citizens that didn't stop it from being implemented, there was a process then of revision and consultation with community groups and civil society, and then ultimately the government ratified it. But what was interesting for my purposes was the explanation citizens gave for why they had voted as they had, either C or no, yes or no, with the final peace agreement, a lot of which had to deal with this question of how wrongs were being addressed. So some people thought that it was simply unacceptable that members of FARC who were implicated in human rights violations would not serve criminal sentences, but were eligible for more restorative sentences if they came forward and disclosed what they had done. That involved clearing landmines or community service as opposed to incarceration. Other people thought it was justified and we should view the peace agreement as a compromise, balancing peace and justice demands. Among those who thought of justice as a compromise, people varied as to whether the balance struck was permissible or not. So some people thought you needed a little more justice in the form of accountability for perpetrators. Other people thought the balance between establishing conditions for peace and accountability was exactly right. So the main point here is people care and people disagree about the justice of the processes that are set up to deal with human rights violations. So there's kind of two different debates going on. One is about particular processes, whether or not punishment is just or not, whether or not a truth commission is a just form for dealing with wrongdoing, and then disagreements about the criteria you use to evaluate those processes. Does justice require what retribution suggests? That if you commit a serious wrong, you have to be punished, and anything less than that is unjust. Is justice properly thought of as a compromise? So you try to think about how you balance deeply conflicting but morally urgent considerations that arise when you're trying to implement a peace agreement, or you're trying to consolidate a new regime after a dictator or other form of repressive government has been toppled. Or is peace just about getting unity within a community that's deeply divided? So I try to make some progress in how we should think about what justice demands. And to do that, I draw on a philosopher, David Hume. He was an 18th century philosopher who very famously claimed that whenever you're talking about justice, there's always a set of background circumstances that generate a particular problem for communities, which principles of justice help you try to answer. So Hume thought the core problem of justice was, how do you stabilize property claims? And he thought that what generates this problem as a problem for communities is the fact that there exists limited scarcity of goods. So if we lived in a context of extreme abundance, it wouldn't really be necessary to try and stabilize claims, because if someone took your iPhone, there's hundreds waiting for you to take over here, or food, or whatever the good is in question. So circumstances shape what questions are necessary to take up. And he also thought that limited scarcity of goods matters because in contexts of extreme scarcity, where your goods are at risk, trying to articulate principles of justice is an exercise in futility, because when extreme scarcity obtains, people will do what they need to survive. And attempts to stabilize property claims won't get in the way of that endeavor. So what matters for my purpose is the thought that if we're going to try and figure out what principles of justice to use to evaluate truth commissions or reparations, we've got to first think, well, what's the problem transitional justice, communities pursuing transitional justice confront? And to do that, we have to first understand the context that communities in transition sort of find themselves in, the circumstances. So that's what I'm going to talk about next. Kind of what are the features at a certain level of generality that are common to places trying to implement transitional justice mechanisms of the kind that I laid out. Okay, I just said that. So there's four. So I'm going to talk about four main circumstances that are common across communities that vary in their details of how these circumstances, what they look like. They vary, lots of variation, but at a certain level of generality, there's commonality. So the first circumstance is what I call pervasive structural inequality. So what this is focusing on is basically what are the terms for interaction among citizens and between citizens and officials in a particular community, whereby terms of interaction, what I'm interested in is what, according to different rules and norms, are individuals required to do or prohibited from doing or permitted to do, and with respect to whom, and what are the penalties, either formally laid out or kind of informally known, if you don't follow the rules. So you can think about political rules in a community. There's a number of different institutions that are relevant here. So political rules that are codified in law specify who it is eligible to serve in political office and the process by which political offices will be filled, such as by appointment or by election. They outline criteria for eligibility. So my husband is Italian by birth. He's an American citizen, but he shall never become president, much to his chagrin. So the criteria for eligibility are such that you can't become president if you are a naturalized citizen. You might have norms among political officials that they just disregard restrictions that are placed on them by law, and that will alter how officials interact with one another. You might have, for example, rules that stipulate the holding of elections over a certain period of time as required, but officials might sort of ignore those rules and just insist on maintaining their position. Social norms can also shape what political processes look like by constraining possibilities that are technically legally permitted. So, you know, if you think about who can run for office, it might be that there are implicit norms about the eligibility of women for assuming public office, or their suitability, or the eligibility of individuals who are from poor backgrounds or less educated, where they're not technically permitted by rules, but there are social norms that shape how people view the relative desirability of candidates who are competing for office. So that's that. Legal rules shape interaction in multiple ways. They stipulate the official language that conduct will be, official transactions will be conducted in. Economic institutions specify who can legally own land and have title, and thus who's allowed to control goods and resources in particular ways. Gender norms can influence the extent to which legal title is respected in practice in many contexts. Educational institutions play a key role constructing civic identity by specifying what must be taught in schools with respect to history. And you see the controversy about history very much right now in the United States, which is all about how do we teach children about who they are and the community from which they come. So that's what I mean by kind of these terms for interaction, and penalties for infraction can be informal, like stigma norms. They can be legal penalties that are enforced or not in practice. But when basic terms are unequal, what I'm talking about there is that different groups within a community face different kinds of constraints or restrictions as a result of how institutional rules and norms are shaped in what they can do, what kind of freedom, effective freedom, this is drawing on the language of Amartya Sen, they enjoy to be educated, to be employed, to participate in political institutions, to be respected and recognized as members of their community, and also different kinds of constraints on the ability of different groups of citizens to shape the terms of interaction themselves. And when inequality rises to a certain kind of level, you know, we can talk about whether or not institutions are legitimate or not. And just a note about constraints, you know, you can have different kinds of constraints. You can have upfront constraints that serve as obstacles for pursuing certain courses of action. So obstacles to pursuing higher education because you don't know how higher education institutions operate or what the application process is because you would be a first generation college student. So upfront obstacles as well as negative consequences for trying to pursue certain courses of action in the form of social isolation or punishment. And that those consequences don't accompany the same choices made by other individuals. So last point to say, 2 points to make on this pervasive structural inequality. Very often there are important material consequences for the inequality that exists in the terms for interaction reflected in the wealth gap in the United States between, for example, Black and white Americans, when you look at the ways in which race has shaped terms for interaction since our founding. So, the sort of resources available to individuals, the material goods that are at their disposal are all affected by what these terms of interaction look like. And there's often kind of underlying rationales for inequality. So Catherine Liu talks about, in the context of colonialism, a sort of racialized ideology of civilization, where who was civilized was taken to be white Europeans, and who was in need of civilization was taken to be folks of color in colonized countries. We can talk about individualism in the US and the ways in which that serves as a justification for eroding any kind of social safety net, because it's all up to you and your individual choices. So that's the first circumstance, is kind of what are the terms of interaction? What are the rules of the game for how you're going to operate and pursue your goals in your community, and the ways in which these can be unequal in terms of the opportunities that are open to different groups of citizens. The second circumstance is what I call normalized collective and political wrongdoing. So there, what I'm talking about is the human rights violations that are often the subject of these processes of transitional justice. Killing, abduction, torture, kneecapping was a common practice in Northern Ireland, disappearing of citizens, land confiscation or displacement. Where when I say that they're normalized, what I'm talking about is wrongdoing that becomes a basic fact of life for members of a targeted group. And individuals have to orient their conduct around the anticipation of being harmed or wronged. So you can think about a lot of discussions in the United States about police violence and how that disproportionately affects Black and brown men and women in the United States, and how that shapes the conversations parents have with their kids about how you interact with the police. It shapes conduct around the police. It shapes thinking about what you need to do to be safe and not vulnerable to certain forms of violence. And it's political in the sense that we're talking about wrongs that often are either committed by state actors or individuals acting on behalf of or with the permission of the state, or political in the sense that you've got groups contesting the state. This is most explicit in the context of civil conflict. Or it might be political in the sense that what explains why wrongdoing becomes normalized is because of an abdication of the role of the government in pursuing accountability for wrongdoing when it happens. So impunity is a common complaint in transitional context as part of what needs to be countered when communities are trying to end conflict or repression. And these first two circumstances, they often interact in mutually reinforcing ways. So if you have pervasive structural inequality, that can be used to justify normalized wrongdoing because it can diminish recognition of the entitlement of members of marginalized or oppressed communities to be treated in certain ways, to have human rights that are in need of protection and respect. Wrongdoing can be justified as necessary in order to protect a particular government that's in charge. And then normalized wrongdoing coming from the other direction can often entrench inequality because part of what it's doing often is trying to terrorize a population into submission, to accepting the status quo and not contesting it because the personal costs for trying to do so are so steep. So those are the first two circumstances that are common across transitional contexts. The third one is arises in periods where transitional justice is being pursued, and it's what I call it is serious existential uncertainty. But what it tries to capture is the fact that there are certain moments in which the future of a political community can become profoundly unclear. And that could be for good or bad reasons. It can become profoundly unclear because there's a signing of a peace agreement, where suddenly the possibility of living in a country in which conflict is ended is possible, but profoundly uncertain, right? But whereas it wasn't really possible before, it becomes possible now. Or, you know, a dictator is toppled and suddenly there's this possibility of perhaps a move or shift to a different form of governance, though that's not a given. And so it's that trying to capture that idea. You can think about in the United States, the racial justice protests in summer of 2020 that were happening nationally, the largest set of protests in our history, even larger than the in terms of the volumes of citizens that were out protesting the streets, where it suddenly became unclear whether the sort of continuance of the status quo or business as normal would continue, or whether there would be radical change in how we think about policing or attempts to deal with racial justice more broadly. So that's what this is referring to. And it's uncertain, these moments or attempts to change, because often a lot of transitions fail. So you might have a peace agreement, but it doesn't stick, and there's a resumption of conflict. Or you might have a dictator, he's gone, but another person assumes office and they're just as bad as worse, or worse as the one before. And so what this means is it's very often incredibly difficult for members of a transitional community to know exactly what narrative to say about unfolding events. And similarly for outside observers, how to think about events that are unfolding and what they mean. And the fourth circumstance is what I call fundamental uncertainty about authority, where transitional justice processes are dealing with past wrongs, but often wrongs in which state actors are implicated, either as direct perpetrators or otherwise implicated in the roles they played in the commission of violations. And so that raises questions about the standing of a government to deal with wrongs in which it's implicated, because the standard story of why it's appropriate for governments to deal with criminal wrongdoing, for example, often appeal to the impartial and neutral role that the government enjoys vis-a-vis the criminal wrongdoing that happened. And also you've got sort of competing standards for authority that are kind of existing at once, where you might have democratic norms that are trying to be established, but they coexist with norms for authority that are tied to individual biographies and whether someone played an important role in a liberation struggle or was an important sort of moral exemplar in a community. So a lot of uncertainty about who has authority and on what grounds to deal with wrongdoing, or more broadly to lead a community. So against that background, what I think is the best way of framing or understanding what the question of transitional justice is, or the sort of question of justice, transitional communities that have this pervasive inequality at the structural level, this normalized wrongdoing, legacy of human rights violations that are confronting periods of uncertainty and questions about the authority of those who claim the right to rule, is what constitutes the just pursuit of societal transformation, where background inequality and normalized wrongdoing make it morally necessary to transform how a community interacts so that wrongdoing is not normalized, and so that the opportunities that are available to all members of a community are more equal in terms of what they can pursue in their life and what role they can play in shaping rules for interaction. The third circumstance, which is bound up with uncertainty, makes transformation possible. So what's different between periods of ongoing conflict, like in Syria, or ongoing repression, is the absence of this uncertainty about whether or not things could actually change. And it's that third circumstance that makes this possibility of pursuing transformation, a live one. And the second circumstance, this normalized wrongdoing, shape how it is transformation can be pursued. Then that's what I mean by the just pursuit of societal transformation. So I'll just say very briefly some things about how I think of transformation. You can fill it out very different ways. I'll just give you one example of how you might think about what it is that needs to be transformed, just to give a model, if nothing else, for contestation and deliberation. So I think when you're talking about societal transformation, what you're fundamentally trying to do is transform relationships. Transform relationships that members of the community have with one another and with officials. And that key elements of that, given how things go wrong in the past, are trying to establish the rule of law, where by that I do not mean sort of law and order as it's commonly talked about, but where legal rules on the books have some purchase in constraining and shaping the conduct of officials and the conduct of citizens. So in almost no context where human rights violations committed by government officials are widespread are what's going on legally authorized. You have prohibitions against torture. You have prohibitions against excessive use of force. You have prohibitions against extrajudicial killing, but that happens nonetheless in ways that is extra legal. So kind of having rules have some purchase on constraining conduct, establishing conditions for the possibility of trust at a very minimum level against a background of profound and often reasonable deep distrust, and then trying to establish conditions where there are threshold opportunities for members of the community to be recognized, to avoid poverty, to participate in institutions and be recognized as equal members. So that's kind of what I think of when I'm thinking about transformation. But insofar as you're doing that, pursuing that by criminal trials or truth commissions or reparations programs, you're dealing with particular wrongs that had specific perpetrators and concrete victims. And the just pursuit requires tending to or ensuring victims and perpetrators are treated in what I call a fitting and appropriate manner, not using victims or perpetrators as sort of mere means, mere tools in the pursuit of broader societal goals. And there's a lot of discussion in law and in philosophy about what that means if you're going to treat perpetrators and victims with the kind of respect they merit, or the kind of demands we can make on them in the case of perpetrators. And so this slide is just kind of articulating the consensus. I don't claim any originality with this list, but repudiating as wrongful the conduct that perpetrators engaged in and holding them to account by judging them as responsible for the wrongdoing and ideally having them acknowledge it, and thinking about what accountability could look like to contribute to non-recurrence. And then for victims, acknowledgement of the fact that they were subjected to treatment that was wrongful, recognizing victims as bearers of human rights and as agents who deserve better treatment, given the very political nature of wrongdoing in transitional contexts, affirming and reaffirming victims as members of a political community, where very often part of what wrongdoing is trying to do is both disincentivize political activity and communicate lack of membership or lack of equal standing, and reparations for harms suffered. There's other things that I think matter that we can think about in thinking about responses to victims and perpetrators. But one thing I'll just flag is that a lot of the aims that are associated with perpetrators and victims are expressive, communicating respect, communicating acknowledgement, recognition. And so I think that there's going to be some cultural contextual factors that are going to shape what kinds of processes credibly communicate those things. respect and acknowledgement, recognition and repudiation. So I don't think that there's any one process that's always required when it comes to dealing with perpetrators and victims. There's going to be some variation depending on the nature of the wrongdoing and what it is that will be effective in communicating the moral aims that you have. Okay, last few minutes, I just want to kind of shift to thinking about what does the EU have to do with transitional justice as I've laid out it. And I just want to give one example of one absolutely vital role that the EU played in ending conflict with respect to Northern Ireland, and a role it continues to play as the UK and the EU negotiate the divorce that Brexit constitutes. It's not the only role, but it's an example of how the EU factors into these kinds of contexts. So the Good Friday Agreement that ended the Troubles in 1998, so ended the period of violent conflict between nationalists who are predominantly Catholic and identify as Irish, and Unionists who are predominantly Protestant and identify as British, was by treating the Troubles not solely as a domestic matter for the UK to resolve on its own, but that the Northern Ireland was ineliminably part of the island of Ireland as well, and had implications for the Irish government as a result. And so, you know, the negotiations involved the British and Irish government, involved the political parties in Northern Ireland crafting together this agreement. But what that agreement established, which is in the news every day because Brexit puts such pressure on it, is a devolved system of government in Northern Ireland, where on especially contentious issues, there was mandatory cross-community support for whatever question was coming up as a matter of governance. It established mandatory representation of Protestant or of Unionist, excuse me, and nationalist political parties in the top ministers that were appointed in the Northern Irish government. It established institutional linkages between the Republic of Ireland and Northern Ireland, and then institutional linkages between the Republic of Ireland and the United Kingdom. It also attempted to establish and address questions of sovereignty, civil and cultural rights, the decommissioning of weapons, and policing. So I'll just talk about two of those things. So, you know, at the core of the conflict and why sort of why Northern Ireland for so many years was seen as a conflict that was irresolvable was because of the fundamentally incompatible claims that nationalists and unionists make with respect to state inclusion. So for those who are nationalists and identify as Irish, the aim has been to reunify the island of Ireland. And for those who identify as British, it's been to maintain an integral part of the United Kingdom. And so what the Good Friday Agreement laid out was a framework for trying to have a both-and model of citizenship, where a birthright of Northern Irish citizens was to identify either as British or as Irish or as both. That was a choice that was up to them. The right of citizens to hold passports that were either Irish or British. The importance of underscoring tolerance of linguistic diversity in the background of the exclusion of the Irish language from any official support or recognition. And in terms of policing, a sort of sine qua non for the Nationalist Party was dissolving, or in the language of today, abolishing the police. That because of the chronic problems that policing had disproportionately in the nationalist community, that it was unacceptable for any agreement not to include a fundamental and radical reform of policing. And so the RUC was abolished, and the Northern Irish Police Force was in its place established, and efforts to try to find ways to include police officials from both communities against a background where that had been almost impossible to achieve in the past was put in place. So this Good Friday Belfast Agreement was approved by a referendum, both in Northern Ireland and in the Republic of Ireland. So the EU, by all accounts, was absolutely essential in making the kind of institutional framework that the Good Friday Agreement laid out possible. Because of the fact that both the British government and the Irish government were under the umbrella of the EU, it provided a kind of framework where the question of sovereignty and citizenship became less salient in the context of Northern Ireland because of the ways that movement of goods and of people and of the blunting of sovereignty was sort of constitutive of being part of the EU. So the border between Northern Ireland and the Republic of Ireland, which had been sort of where a lot of violence had occurred during the course of the Troubles and is a deeply traumatic site for many Northern Irish citizens because of the history of the Troubles. There was the possibility of moving goods and people. And, part of what's so regrettable about the decision by the United Kingdom to leave the EU, and in particular, the very hard, the particular interpretation of leaving that has been adopted by the Conservative government, is that it puts pressure on precisely the issues that the Good Friday Agreement tried to resolve that were at the core of conflict. So there's already been pressure put on the ability of Northern Irish subjects to claim for themselves the identity as Irish and only Irish, not British at all. Worries about the fact that that allows for kind of rights of EU citizenship or EU privileges by virtue of holding an Irish passport that won't be available to everyone in Northern Ireland, let alone the United Kingdom, as a result of leaving. Because of the ongoing dissatisfaction by some unionist parties with putting the border between the EU and the UK at the Irish Sea, as opposed to at the border between Northern Ireland and the Republic of Ireland, which was done precisely as a negotiated agreement, precisely because of the role that the land border between Northern Ireland and the Republic had played during the conflict. The rejection of that now, of course, leaves the only possibility that exists for a border to be the one that was the site of the violence during the Troubles. There's been a spike of distrust among both communities as the implications for leaving and the ability of both communities to be connected to the place that they identify with is being put back in an either-or context in a way that when both countries were part of the EU and the EU framework was in place for negotiating the Good Friday Agreement, that sort of hard either-or choice didn't need to be made.